Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents, and you take it from there. We're back again June 4th with a Supreme Court opinion on an order in the case Doe v. Seattle Police Department. Alright, something new here that we haven't actually addressed yet. This is not a dissent, but just a statement on a denial of an emergency stay application in the case John Doe v. Seattle Police Department. First, though, as usual, backgrounding of the case. This case has to do with 4 current or former officers of the Seattle Police Department who were investigated by their department for being in Washington, D.C. on January 6, 2021. And we all know what happened on that date. The investigation looked at whether they were involved in any illegal or inappropriate behavior. 3 of the officers attended the rally at the National Mall and then returned to their hotels, while 1 officer went to the U.S. Capitol, but investigators found he did not break any laws or department rules. So, what is the issue now then? The officers are concerned that records from that internal investigation, specifically their names and answers to politically sensitive questions, will be released publicly. The officers say they were forced to answer political questions like why they attended the rally, were you supporting a political group by attending the rally, etc. They're not trying to block the release of all records, but they just want their names to be redacted or blacked out. The officers applied for an emergency stay for a legal freeze to pause the release of the records while a legal appeal is going on. The application went to Justice Kagan, who referred it to the full court, where the full court denied the request without a full hearing or detailed ruling. This is where we get to the document in question, the statement from Justice Alito. Alito pointed out that the officers did not ask the Washington state courts for a stay before coming to the Supreme Court, and the state court's ruling had actually already taken effect more than a month earlier, so it was hard for the Supreme Court to see where the officers could explain why immediate harm would occur without a stay. He also pointed out that anonymous political speech is protected by the First Amendment, citing past Supreme Court cases like Talley v. California that affirms that right. However, the Washington Supreme Court said the officers had no expectation of anonymity because they didn't hide their identities while attending the rally. Alito expressed his disagreement with that logic, saying the issue was not whether they're anonymous at the rally, but whether it's constitutional to publicly disclose their personal responses to politically sensitive questions they were forced to answer under threat of job loss. To be clear, though, this is not a full ruling, just a denial of emergency stay request, so there is still a chance that the case is granted certiorari and heard by the Supreme Court if steps are taken to do so.
Full video located on our channel.